Well, we're right on time, so we will get started here, and I'm sure people will join as we go. But welcome everybody to our webinar. This webinar is all about how we can get more participation in informal resolution programs related to Title IX. So I think, as most people know, the 2020 Title IX amendments introduced informal resolution as a legitimate method of resolving Title IX disputes in lieu of the formal hearing process. So what's interesting now is the Biden's administration proposed amendments actually support the use of informal resolution even before a formal complaint is filed. So interesting happenings. We're at the forefront of Title IX right now, lots of things going on. The problem is students may not even be aware or understand what informal resolution means and how it can be beneficial to them. So, and due to the chilling effect caused by sort of the adjudicatory, sorry for that word, nature of the formal hearing process, you may have complainants that are reluctant to report sexual misconduct at all. So what we're hoping is we can impact their ability to move forward from that experience in a healthy way. So how do we get all the parties in interest, from students, faculty, Title IX professionals, to utilize this informal resolution process instead of simply pushing forwards towards a full hearing, right? So that's what we're going to discuss today. I hope everybody's interested in this. Obviously, if you've joined the webinar, you are. I'm going to give a brief introduction of our speakers, and then we'll actually get into sort of the more panel discussion about this whole thing. So first, we have Cara Hardin. Cara is the Title IX Deputy Coordinator at Marquette University. I'm going to read a lot of this so I don't screw it up. She's Marquette's lead investigator for allegations of sexual harassment and discrimination. Before joining the Title IX office of Marquette, Cara actually served as special counsel in the Ball State University Office of General Counsel, advising on employment-related matters and Title IX compliance. Cara previously served as the deputy prosecuting attorney assigned exclusively to the prosecution of sexual assault, intimate partner violence, stalking, and crimes against children. So very serious stuff. Cara began her legal career practicing employment law at a large Midwestern law firm. She's a graduate of the University of Indiana and the University of Miami School of Law. Then we have Jackie Wernz. Jackie's a partner in the Dallas office of Thompson Horton. Jackie is an experienced trainer in all issues of school, college, and university regulatory and legal compliance issues, including Title IX and other federal civil rights. She served as an outside investigator, decision maker, advisor, and informal resolution facilitator for Title IX complaints. So a lot of experience, particularly with what we're discussing today. In addition to over 12 years in private practice representing schools, colleges, and universities, Jackie was a civil rights attorney for the U.S. Department of Education Office for Civil Rights. Jackie attended the University of Arkansas at Little Rock and the University of Virginia School of Law. Finally, but not least, Lucretia Taylor. Lucretia is the Title IX coordinator at Wichita State University. She's responsible for investigating complaints of sexual misconduct, discrimination, and harassment. Prior to Wichita State, Lucretia was a Title IX investigator at Kansas State University, handling complaints under Title IX, 7, and 6. Lucretia also served as an EEO investigator at Spirit Aerosystems and a senior manager for Spirit's diversity and inclusion program. Prior to Spirit, Lucretia was an assistant HR director at Friends University. Lucretia is a graduate of Wichita State University and Washburn University School of Law. I'm going to smooth this out, I promise you. But now that I'm not reading as much, it's going to be a lot better. So first of all, thank you guys for participating in this. We're very excited. Just a very brief introduction on me. I'm an attorney, but I'm the founder and chairman of New Era ADR, which is a technology company that builds platforms to facilitate dispute resolution, and that includes Title IX. So that's very brief about me. I'll be moderating this panel, and once again, thank you guys. Super excited to have you and ready to get rolling. One quick disclaimer, since everybody here is an attorney, we just want to say the information provided during this webcast does not and is not intended to constitute legal advice. It's just for general information purposes only. So don't take this as legal advice, but hopefully you learned some good stuff today and there's things that you can put into practice. So are we all ready to get rolling? All right. Cara, I'm going to start with you. When we talk about informal resolution, what exactly does that mean? And maybe a better question is, what can informal resolution mean?
Hi, Colin. Thanks for having me today. I think that's a great question, especially when you talked about, how do we get parties in interested in informal resolution, well, not only do we have to be able to explain it, but we have to know what it means ourselves. So what is it and what can it mean? So as you already alluded to, the Title IX 2020 amendments, or final regs, as some of us call it, identify informal resolution as an alternative and less adversarial resolution process for formal complaints alleging sexual harassment. Informal resolution is a type of conflict resolution strategy, one that empowers the parties to negotiate the outcome of the case with the help of an unbiased and conflict-free third party, as opposed to having those parties go through a live hearing and risk an outcome that may not be favorable to them. So, Colin, the 2020 amendments identify a broad range of informal resolution methods, and that includes mediation and restorative justice. So how it works, that if the parties enter into informal resolution by whatever method that your institution offers, if they reach a resolution, the formal complaint concludes and the parties agreed to abide by the terms of resolution. That's it, the case is closed. If a resolution is not reached within that informal resolution process, the formal complaint returns to the formal grievance process. Now, Colin, before we move on, I think it's really important to know the impact that this alternative resolution strategy has for us. I think, as many of us who are Title IX professionals in the industry, we can probably agree that one of the most controversial elements of the 2020 Title IX amendments is the requirement that post-secondary institutions hold a live disciplinary hearings that allows for cross-examination of the parties and witnesses. And understandably, critics have argued that this environment, which includes cross-examination, threatens to re-traumatize complainants, traumatize respondents and witnesses, discourage reporting misconduct, makes the process unnecessarily adversarial. And so I think OCR recognized that possibility when it was drafting the final regulations, because OCR specifically says in the preamble that, subject to certain limitations, informal resolution may provide a beneficial outcome for the parties.
Sure. As I understand, informal resolution, though, is subject to certain limitations. Can we just discuss a little bit about what those limitations are?
Sure. Well, those the limitations that are explicit in the final regulations are threefold, really. Institutions cannot offer informal resolution to resolve allegations when an employee is the respondent in a sexual harassment case and a student is the complainant. So hands down, can't ever do that. Institutions can't require or pressure the parties into the informal resolution process. So how you're having that conversation about informal resolution has to be such that it doesn't feel like they're being pressured to go into that process. And then the third spoke is the limitation is that your informal resolution period cannot be an indefinite period of time. It must conclude within a reasonably prompt timeframes, just like the entirety of the grievance process. So those are the explicit limitations in the regs.
Got it. I just want to latch onto that first one, that we're going to move on to Lucretia for some questions and Jackie for some questions. But so what you're saying is, but for cases when a complainant is a student and an employee is the respondent, if you have both parties consent, everything else, all other formal complaints of sexual harassment can be informally resolved.
Well, the technical answer is yes. Now, should all types of sexual harassment cases be resolved through informal resolution? No, I don't believe so.
Sure.
I believe there are cases where formal complaints alleging sexual harassment are appropriate for informal resolution and those that are not. Now, it's the Title IX coordinator's discretion and their decision whether to offer informal resolution. And that decision should be on a case-by-case basis. I would say that generally formal complaints alleging hostile environment sexual harassment are amenable to informal resolution. Another type of case that is typically amenable to informal resolution are stalking cases. that are potentially connected to a mental health or personality disorder. When it comes to sexual assault and dating and domestic violence cases, in some circumstances, it may be appropriate to resolve those cases by informal resolution. But I really want to caution, however, that sexual assault and dating and domestic violence cases specifically are the most challenging to informally resolve due to the nature and I would say intimacy of the harm and the power imbalances that are often associated with those offenses. So I would say that a Title IX coordinator should proceed with caution when offering informal resolution in these types of cases. I would say that those cases that are generally not conducive to informal resolution are those that involve physical or threatened violence, predation, intimidation, a dangerous pattern of conduct, or of course, where the power differential is significant and under the circumstances could exacerbate the harm. But what's nice about informal resolution, and I'll wrap this up quickly, if a Title IX coordinator is unsure if a case is appropriate for informal resolution, the regs allow them to take a wait and see approach. Informal resolution can occur anytime before there's a determination of responsibility. This means you can offer informal resolution immediately following the filing of a formal complaint and after the parties receive the notice of allegations. Or if you're unsure whether informal resolution is an appropriate method of resolution in a particular case, you can move the case through the investigation process to get idea of the facts and circumstances in the case, and then offer informal resolution if you think it's appropriate. The parties may get all the way mostly or halfway through the hearing process and realize this isn't what they had hoped it would be, and then request informal resolution at that point. So there's lots of flexibility here with informal resolution.
Perfect. Lucretia, let's go to you and sort of the nuts and bolts of actually using these policies and doing things like this, doing informal resolution within your institution. Have you ever used the informal resolution process for any of your Title IX related matters? And from your perspective, do you consider it to be an effective method of resolving these types of cases?
I've used the informal resolution process in 2 cases that we've had at Wichita State. And thank you, Colin, for having me on this panel. It's a pleasure.
Of course.
We were successful with one, and we're still going through kind of the grievance process with the other one. But I do believe it's beneficial for an institution to utilize the informal resolution piece. In one instance, it was more amenable. You know, the parties were willing and able to work something out. And so we utilized that process to come to a conclusion that was amenable to both parties. I mean, everybody was okay. Nobody wanted to go through the whole grievance process. But I will go back to what Cara had said earlier about making sure that complainants and respondents understand what the informal resolution is. Because I think that is important, that they understand that, you know, we're working towards an end, right? We're working towards a means to get a resolution without the formal grievance process. So it's important. And so in the one case that was successful, it was not, you know, the ones that Cara cautioned us about, dating violence, domestic violence, so that the individuals were more amenable to say, hey, you know what, there were 2 students, we're done. I want an apology.
Sure.
And that's what we got. So it didn't seem feasible to go to the entire formal grievance process when the party just wanted an apology. And the responsible party was agreeable to that. So we've been successful with one, and at any point in time, the complainant can say, you know what, I don't want to go through this process. I want to stop. I want to proceed on to the formal hearing. And that's where we were. But I think as a Title IX coordinator, you really have to look at the facts, look at the parties involved, offer that as an alternative to the actual hearing process. Because when you explain that hearing process, to the individuals, they may decide, no, I don't want to do that. And so we want to make sure that they understand what it is, what it isn't, and how to best proceed with that. I think too, we had really good advisors working with our complainant and our respondent in getting a resolution. And you do need that, I believe, as working with the informal resolution process, to have good advisors really give good advice to their complainant and the respondent.
Speaking of advisors, so Jackie, we're going to move to you as outside counsel who advises clients on this type of stuff all the time. What do you counsel your clients about with respect to informal resolution? Do you recommend it? If you do, what kind of informal resolution? Tell us your thoughts on that and how you handle this as an outside attorney.
Sure. And thanks so much for having me, Colin. This is great. Great panel to be on. So I highly recommend informal resolution. The way I tend to describe it is, it's a win-win instead of a zero-sum game. And particularly in schools, colleges, and universities where people are often going to be returning to your community together, whether they like it or not, and whether you like it or not. Having everyone reach a resolution that they feel at least good enough about to sign on the dotted line is a really good thing, because it can help to ensure not only that you're able to address the particular complaint that you're dealing with right now, but that hopefully you're going to help avoid any future friction between those parties for however long they may remain in your environment together. So I really am a huge fan of it. I was thrilled to see that we not only have a lot of higher education institutions on this call, but quite a few K through 12 institutions. And I would say that the higher institutions that I work with, higher education institutions I work with, do tend to offer informal resolution much more frequently than the K through 12 institutions. And I think a part of that is a result of resources and individuals with the appropriate training and background and experience. You're much more likely to find that in a higher education context than in K-12, where they are much less likely to have kind of the large Title IX apparatus. So, but nonetheless, I am constantly telling K through 12 schools in trainings that I think you're really missing an opportunity here. You need to be considering this. And particularly in light of the new Title IX regulations that have been proposed, although we don't know what that's going to look like in the end, we can pretty much tell at this point that we're going to have a much larger number of complaints that are going to have to be processed through the Title IX grievance process. It'll be a little less onerous of a process, but nonetheless, it's a process. And so I think people should be thinking now about how to get informal resolution in place and having it ready for when those new rules come into effect, when you're likely going to see an increase in the number of complaints that you're going to have to process using the Title IX process. As far as what I would recommend, I am kind of I'm a little boring when it comes to what I think is the appropriate method for Title IX sexual harassment cases. I am a big fan of shuttle diplomacy, where you are mediating, you're doing mediation with your informal resolution facilitator going between the parties. I like when it's in person, because I think when it's in person, it moves things along a little more quickly. You're more likely to get to a yes or no within the day, for example. Whereas if you're doing it electronically or not contemporaneously, you're calling one person on one day, calling another person on the other day, it could sort of feel like it goes on forever. But the key, I think, to the method, at least the way I would recommend it, is that I will never bring the parties or their advisors face to face. I will never bring them into a meeting together, because I just don't think that is, I think the risks outweigh the benefits of doing that. And a lot of that gets to what has already been said about the risk of re-traumatization, the risk of initial traumatization. I actually have had numerous successful informal resolutions involving allegations of sexual assault. And so I'm not as nervous about schools using those. I do think it is incredibly important to have a high quality trained informal resolution facilitator to do those things. And so you know, I am a huge fan. That's part of the reason why I was so glad to be invited to be on this panel, because this is something that I think everyone at every level should be doing more of.
It's interesting you mentioned that, because there's always the theory that if you bring parties together prior to a mediation, that is some sort of cathartic moment. And I've always felt it's actually a terrible moment, and that raises the ire and the anger, and sort of sets the stage for what can be a failed mediation. But a lot of interesting points here. I want to go back to a couple of things that both of you were talking about and sort of extrapolate off of what you said. So for Lucretia, why hasn't informal resolution been more universally adopted? This seems like there's really no downside, right? So why do you think that it isn't more pervasive in resolving Title IX complaints than it is right now?
I think it's just lack of knowledge that it is an option for you to utilize. I think we automatically assume that when we have an informal investigation, we will proceed to the actual hearing. And I think that is part of the issue, is having Title IX coordinators say, this is an option for you if it's something that you are amenable to.
Got it.
Yeah.
So this is sort of a corollary to that, and I'll ask this one to Jackie. When you weigh the differences between informal resolution and doing a formal hearing, what are the downsides to that formal hearing? What do you perceive as the downsides to going to a formal hearing process?
Well, so first of all, one thing to keep in mind is that under the regs, there's the hearing process in higher education. For our K-12 folks on the call, there is a sort of what I call like a hearing on the papers. It's there's not actually an in-person hearing, it's written cross-examination. However, even though the live hearing is surely more traumatizing for everyone involved, because of the young age of the students who are involved in K-12, I think that the risks with respect to the hearing are very similar, no matter if it's in person or on paper. And for me, the main concerns are, which Cara mentioned earlier, one of them, which is that you're requiring a person to submit to questions about the incident, including from the other party, their advisor in the case of a live hearing, but from the other party directly in writing in the K-12 space. So either way, the parties are having to, potentially go through this really awkward, traumatizing moment of having to answer questions from either the person who is alleged to have abused them or the person who's accused them of sexual harassment. So I think avoiding that is a really big it's a really big upside when it comes to informal resolution. I also think though that the win-win part of it is, to me, probably the most important thing is just we've recognized in education, I think across the board, the benefit of restorative practices in discipline as opposed to punitive practices. And although the parties can agree to punitive discipline as part of an informal resolution, that's not usually what parties are agreeing to in these things. And so just being able to avoid that situation where someone feels like they won or they lost can really, I think, be a big positive with respect to the informal process as opposed to the formal process. For schools, I mean, it's a no-brainer. The difference in time, cost, resources expended, number of people who have to be involved if you have a successful informal resolution versus completing the entire grievance process, it's night and day. You know, if you are able to initiate an informal resolution process early enough, you may only have to actually involve the Title IX coordinator and the informal resolution facilitator in order to complete the process. Whereas if you go through the entire grievance procedure, you are going to be using at least 4 individuals, if not panels of individuals, plus the time and energy of all the witnesses. And it's a night and day when it comes to the resources from the educational institution.
Interesting. And just so you know, I've got Q&A up. This is fantastic. There's a bunch of questions going up on Q&A. Some people within that are just, watching the webinar are answering, and that's fantastic. I would also encourage our panelists, if you're not the one answering a question, obviously I know you want to listen to and make sure that everything's going smoothly as far as what your next question is. But if you can jump in here and answer some of these, that would be great. And I will try to get to some of these at the end as well, just to get as many of these questions answered as humanly possible. So tying back to something Jackie was just talking about and the traumatization, Lucretia, can you talk about informal hearings that you've seen, what the impact actually was, and obviously no names, but what the impact actually was with complainants and respondents?
In terms of the informal resolution piece?
No,
the formal grievance piece?
Formal grievance process, yeah.
Yes, so one case that we actually did take to the formal hearing, it is, like Jackie said, it's the kind of the re-traumatization of the individual. And that is what's really impactful. It's important that we go to an informal resolution piece. Parties walk away feeling unfulfilled. There is no win-win situation. And so when we have those cases, and I'm just kind of talking here from experience and seeing it, is that it's just we felt like we re-traumatized an individual, and they were not happy with the process, and everyone was it's just not good. Everyone was not happy with that process, and I believe because it is so long, and witnesses, and you walk away everyone walked away feeling that it was. It didn't work, and we did not have a finding of responsibility at the end. So it was just a re-traumatization. No one won. No one won. And I think that the key, again, Colin, as we're talking too about controlling the narrative, and I believe Jackie had talked about that as well. When you're at the hearing process, you really are not able to really control the narrative. And so it is not a win-win situation. And we did have our complainant who felt very traumatized at the end.
Yeah, never a good thing, right? To have to relive the pain and the misery of whatever happened to you before. And if it ever reaches the point where there's accusations and questions, it's not a good thing. Jackie, I have a question for you, and I swear we're getting back to Cara in a second here. We're not just going back between Lucretia and Jackie, but one thing that's always really interested me, and we just did a poll question asking who serves as the informal resolution facilitator. And to be totally honest, it's now gone from my screens, but it was there, and I'm pretty sure I got the number right. And only 11% of the responses said that they use somebody from outside the university. And this is my curiosity, is if you are a complainant, isn't there a concern of a conflict of interest and bias? If you say, I have an issue, and maybe that person is an employee or whatever it may be of the university, a professor, another student, the university has probably at least, and this could be any school, I don't mean to keep using university, but to keep it simple, I will. Isn't there a concern that if that person is employed by the university or somehow affiliated with the university, that there may be some bias or conflict of interest that's a problem, and the person who's handling the hearing or the informal resolution process, if they're related to that university, wouldn't that remove some of the students, I guess, how fully they believe in the process? So I'm asking about conflict of interest and bias and what you think about that.
Well, I can tell you that the vast majority of cases where I have been brought in to do an informal resolution or an investigation or, a decision-making role, it's because there's a concern, something about the case there's a concern that there would be a perceived conflict of interest if someone from the university or the school was the one doing it. So that does come up. The Title IX rules are pretty clear that we shouldn't make generalizations about bias and conflict of interest, that we want to look at it on a case-by-case basis. There will certainly be many circumstances, whether it's the fact that, you know, the person who is one of the people who's involved has a role that's very high in the educational institution, or other factors that might create a risk of conflict or a feeling of bias. I think that my concern with having internal folks do informal resolution is less with conflict or bias and more with just making sure that those individuals have sufficient training that they're able to do it well, because mediation is just not something that you roll in off the street as a professor or a student or whatever and
Right.
have the competency to be able to do it. So I was curious. I didn't see the answers to the poll because I think it was talking when it came back in. So I just
Sounds
closed
quick.
it.
Yeah, it was up and gone.
I would be interested just in the sense of, you know, what I get much more concerned about with bias, conflict of interest is if a member of the Title IX team, so someone who served and, oh, thank you, there we go. So we've got, so 49% of informal resolutions are being done by the Title IX coordinator or individuals within your Title IX office other than the Title IX coordinator. Those would concern me more when it comes to bias and conflict of interest. And here's why, because to do a good informal resolution, you need to get those parties to tell you everything. You need to know the ups, the downs, the weaknesses, the strengths of their case so that you are able to use that to help craft a remedy that the parties will be likely to agree to. And if you're going to turn around and be the person who's serving as the Title IX coordinator, if this matter goes back to investigation and decision, or serving in some other role on the Title IX team, how is that going to make the parties feel when they've just opened up to you about all of the strengths and weaknesses of their case, and then now all of a sudden it didn't work, and now you know all of those things, but you're still involved in the process. So I get very concerned about that and think that people need to be really thinking carefully about who's serving in that role and what their potential knowledge from the informal resolution process, what impact could that have on, as you said, the sense of sort of fairness and justice in the formal process if it were to resume.
Sure.
Cara, can I jump in for a second though?
You absolutely can. Please do.
And follow up with Jackie, because one of the things that we did was use an outside source for an informal resolution case. And I do agree with what Jackie is saying about, you know, making sure that they're, you know, being concerned about bias and being concerned as a Title IX coordinator. Because in one particular case, as the Title IX coordinator, I'm also the investigator. So I could not do an informal resolution. So it was much easier to have someone from the outside come in and take that role as the mediator in that informal resolution. And it would have taken away any type of bias that might be, you know, an accusation of bias, because I'm working in both hats at that particular point in time. And it was just easier, and I felt more comfortable with the process happening, and to take out that piece of that bias.
Interesting. Cara, I'm a little bit off script here, but I'm curious to get your take on this too. And what you think makes a really good informal resolution facilitator. But once again, first, I'd love to get your take on the idea that the Title IX coordinator of the Title IX office should not be that party. And if not, who that party should be.
Right. I do have a strong opinion about it, and it lies the same with Jackie's. So we saw before the final regs came out, we were used to seeing the Title IX coordinator as being the Swiss Army knife to everything Title IX. They would come in and offer supportive measures, investigate, adjudicate, make the decision, do the sanctioning, all of these things, right? But we know from the 2020 regulations that there is a specific provision throughout about conflicts of interest. Not necessarily, I mean, and bias too, but conflicts of interest. And so how I look at it is similar to how Jackie and then Lucretia added this about once you start playing multiple roles, there's going to create even the potential for a conflict of interest, right? And so when you look at it another way, both Jackie and Lucretia have given you examples. That Title IX coordinator is always responsible for providing supportive measures. And sometimes that means you get to know the intricate details, particularly of a complainant, in terms if they are having mental health struggles, you are working to get them excused absences, to get them counseling, to get them an advocate. How would the respondent feel if you then came into that mediation already having this full relationship and knowing very private things about the complainant, but you've only just sent the respondent a notice of allegations? So if you're going to do that, I think you've got to be really transparent with the parties about what your communications have been before the informal resolution to try to mitigate that potential conflict of interest. But I think it's a shaky ground. So when you ask an independent third party to come in and facilitate that informal resolution, I think you're automatically staying above board and avoiding any even appearance of impropriety.
Interesting.
Yeah, and if I could just one more comment on this that I just thought of. You know, the Title IX rules require you to explain the consequences of participating in the process in informal resolution to the parties before they agree to do it. And so if you are in an institution where you are going to have someone who's going to be wearing multiple hats, you really need to think through what the potential consequences are of having the Title IX coordinator serve as the informal resolution facilitator, but then coordinating the case if it goes back to the formal process, for example. So I would just encourage people to make sure they're thinking through that beforehand, because you need to explain to the parties so that they can make an informed choice about whether to participate in informal resolution.
Sure. So I would guess, and I don't know this for certain, but perhaps a blocker to this being utilized more widely is the fact that the administration of whatever school it may be, whether it's K through 12, college, university, doesn't really matter. But maybe the administration not really understanding what the informal resolution process is. So Jackie, I'm curious, what do you think schools need to understand about this process? And what would you tell administrators to help get this more widely adopted?
I think that the biggest thing is just making sure that those in leadership know that, yes, it may require some initial investment in order to get some folks trained up or to use an outside service for it or an outside consultant for it, that ultimately this will likely lead to less resources being used in Title IX processes, especially once you're able to start doing it really well. So I think, I don't know, I just find that in my experience working with leadership of educational institutions, you know, you talk money and that's always what, you know, that's what they're going to hear. So I think explaining the potential, those positives is really important. You know, I think that they need to understand that in order for, at least currently under the current rules, in order for the informal resolution process to go forward, parties do have to have a formal complaint on file before there can be the informal resolution process. Sometimes people see that as a hindrance because they say, you know, I have someone who is really adamant that they don't want to participate in the formal process, so they're not going to sign a formal complaint, but then they can't use informal process. We only have to worry about that until the new regs go into effect, probably. But in the meantime, what I'm usually recommending people to consider is to talk to the complainant to say, file a formal complaint. We'll try informal resolution. If it doesn't work, you can submit a request to the Title IX coordinator in writing to withdraw the complaint. And so at that point, the Title IX coordinator can withdraw the formal complaint. So making clear to the parties that, just because we start the informal process doesn't mean that you are going to have to go through the formal process if that doesn't work. I think those are a couple of, big things. I would say too, I do think that the shyness about it, some of it hinges on the fact that particularly in higher education, we are dealing with a lot of cases involving, pretty serious sexual misconduct. And although I would probably never encourage, and I certainly probably would never sign up to do an informal resolution if it were a case involving like a violent rape, for example. I think not shying completely away from using it in cases involving sexual assault may lead to using it in more frequently, because a lot of our cases involve sexual assault. So whether it's fondling or an intoxication situation, there are certain types of sexual assault that might actually be okay to handle through informal resolution if you have the right mediator.
Sure. You touched on something that I think is going to be very significant for anybody who's listening, which is budget, right? And Cara, I'll direct this to you. What are the associated costs of informal resolution, and how do you mitigate those, or better yet, how do you work those into a budget? And does that have to be at the beginning of the year? Can it be mid-year? But this concept of, hey, if you're going to have to spend money on this, obviously the administration is going to take a heightened look at it. So what are the costs and how do you deal with those? Oh, I think you're on mute.
Sorry.
Sorry.
If you're going to keep your informal resolution facilitators in-house, then the cost is going to be pretty minimal. You're going to pay to get them trained, because the final regulations require that the person who informally facilitates the resolution has to be trained in whatever method you're offering. So if you are saying we are offering facilitated negotiation, mediation, whatever you want to call it, restorative justice, then that person has to be trained in that method. So you'll pay for the training. Otherwise, if you build the informal resolution facilitator job responsibilities into a person's job responsibilities, then there's going to be minimal cost. But we've just talked about all the benefits of kind of outsourcing. So I think that you're going to be looking at, when you're looking at outside third parties to conduct informal resolutions, you're going to look at it the same way as you would look at an external investigator, an external hearing officer, such as their hourly rates. Now, we all cringe, right, when we have to contract with people with hourly rates, because we never know, is it going to be done in 2 hours or is it going to be done in 80 hours? And so that is a really scary, unpredictable place to be when you are subject to a budget. So you can contract with outside third parties, or I know New Era, not to brag on New Era, for example, Colin, but to enter into an agreement where you're basically saying every informal resolution is going to be for this amount. Up to a point, or some sort of agreement where you can really know what you're going into and what it's going to cost you, regardless of whether it resolves or not. So I think that for those of us who don't have big budgets, that's a really important factor, because as we all know, when we hire out investigators and hearing officers, oh my gosh, we have no idea how much that's going to cost. And then your administrators are really going to pay attention.
Yep. Flat fees are a good thing.
Yep.
So I'm going to stick with Cara here to really get into this concept of how do we more widely adopt this as a process? How do you think we could educate parties in interest, whether that's students, faculty, employees, administrators? How can we educate them better about the informal resolution process, and what exactly do they need to know? I guess, how do we make this more pervasive in an institution? Because obviously the Title IX office knows about it, the employees know about it, but considering a lot of the university at large probably does not, what's the best method of educating them about this process?
Right. And I think that you can't, okay, so if you're going to offer informal resolution, you have to have it in your policy and you have to discuss it. But let me tell you something. Nobody's really reading your policy because it's long
Sure.
and it's scary, right? And so I think that the onus on getting party buy-in or talking about it throughout the institution as an alternative resolution method is by being transparent and speaking about it. And so our practice at my institution is when we have any initial meeting with any of the parties, it's usually the complainant first, right? We will talk about the availability and option of informal resolution. And we don't talk about it in absolutes. We say that may be something that will be available depending on the facts and circumstances of the allegations. So that's our first touch point. We would do the same if a respondent came in and says, hey, I hear that a formal complaint may be filed or a formal complaint is filed. The second touch point is that we talk about informal resolution in the notice of allegations. And we explain it such that, because we also talk about the hearing process and the investigative process in that notice. Another touch point, let's say that the parties you can tell are really struggling, they're having trouble, then you can revisit it then, maybe after the investigative process. If you think that the parties would benefit through informal resolution, then, in your communications, when you transfer the investigative file or the investigative report, just a reminder, the informal resolution process is available to you, but also not just saying informal resolution, they need to know what it is. So that's why it's really important for that first touch point with the parties to explain it.
Sure. So I'm going to pass this a little bit of the similar question to Lucretia and then Jackie. What do you guys think are the keys to getting more universal adoption of informal resolution within institutions?
I agree with Cara. I think it's that initial touch point with your parties, your complainant, and making sure that individuals understand that this is an option for them. And Jackie hit on something that I had a conversation earlier this morning with an individual who is wanting to move forward with a formal complaint. And in offering the supportive measures, I also talked about the informal resolution process and that it is, an option, but it's solely up to whether they choose to do it or not, but it is there. And so you have those initial touch points. I think it is important if you have internal investigators that you may be overseeing in your Title IX office, that they do those initial touch points as well, and talking to your complainant and your respondent about the informal resolution process. I also talk about making sure that individuals look at it from a controlling the narrative piece and how they want the resolution to be. But again, I agree with Cara 100%. Doing the touch bases, your complainant, your respondent, at any point in the resolution and in your notice of investigation and allegations, and making sure that that's a piece of it as well. Because she's absolutely right. We put, here's the policy. You can read the policy, but no one reads the policy. And at each time I have a conversation with a complainant or a respondent, I want to make sure that they understand that that is part of the process as well, which is the informal resolution piece. So that's what I do. I do it every time we get someone who wants to move forward with a formal complaint. And I tell them at any point in time that this is still available to them. We're getting ready for an actual formal hearing, and we had a pre-conference hearing the other day, and it's still, you may still enter into an informal resolution if that's, what you want to do. So I agree, and also from an economic standpoint, and then I'm gonna let Jackie have it, but from a financial standpoint, as a university, we have a set budget for hearings, right? And I think most universities do. One hearing that can literally, depending upon the complexity of what you have, can literally wipe out a budget. And so the informal resolution piece is much less money. And even if you contract with outside third party, I still believe that it is cheaper than having a hearing that could take 4 hours, 40 hours, however long that takes. And it literally can wipe out a departmental budget.
Wow. So Jackie, same question to you. What do you think are the keys if you're counseling clients as an outside attorney to getting more universal adoption of this process?
I think the number one thing is that it's going to be the faith in the institution with respect to the competency of the process that's offered. We had a great comment in the Q&A. I've been in there trying to answer questions. So,
It's great.
but we had a great comment in there about, a lot of times that the make or break of an informal resolution can depend on how the parties feel, and sometimes about how they feel about the office, the Title IX office itself, and whether they think that it's, giving them a fair shake or doing enough for not just them, but for their type of party, for complainants generally or for respondents generally. And so really offering a successful program is the first step, I think. So having something in place that's really well thought out with good solid procedures where you've thought through a number of the different consequences. So that's something that I'm often helping with is, writing those internal procedures, for example, to kind of think through, how are we going to handle an informal resolution if it comes up? And what is our letter what is it going to look like? What is it going to describe to parties as the consequences of participating? And so really thinking through all of that and having that in place, and then just, having good, strong facilitators, I think the word's going to get out on your campus that, hey, this is the way to go because it's way better than that other process.
Makes sense. So from purely a logistical standpoint, let's kind of get into how you actually do this. And I know we're getting close to time here, so we'll run through some of this as fast as we can. But Cara, how do you actually implement an informal resolution process at a school?
Sure. Well, I think I alluded to this earlier. You've got to have it in your policy, right? You can't offer informal resolution unless it's in your policy. And I would say that the final regulations really provide you with a great, the language that has to go in your policy, right? And that's, you would talk about what informal resolution methods you offer. You have to talk about the voluntary participation requirement, the circumstances that preclude the parties from resuming the formal complaint process. And, I saw that question in the chat, so I'm going to stop there. So if parties informally resolve, meaning they reach a resolution agreement, the case is done, they sign it, they can't then go to the hearing process, right? So once that's signed, you can't really go back. And then you've got to talk about the record keeping requirements that are talked about in the final regs, the consequences for participation in informal resolution process, which means, is your informal resolution process confidential? Will it be subject to appeal? What are the penalties if a party breaches the resolution agreement? And then you should also, as we've talked about ad nauseum, highlight that the process will be facilitated by a neutral, objective, and trained facilitator. Look, in our Title IX world, there are two areas that I feel get Title IX offices into litigation. Obviously, one, the deliberate indifference argument, but number two, and this has become really visible from the final regulations, is challenges on conflicts of interest in an unfair process when a conflict and bias exists. So secondly, and we've also touched on this, we have to have those people trained. So we can't just say, oh, we've been doing Title IX for 15 years, we can informally resolve, no problem. Being a Title IX coordinator, being an investigator is not the same as facilitating an informal resolution. It's a completely different ballgame, and the final regulations, acknowledge that. And that's why they have put in the robust training requirements for facilitators of informal resolution. So I think that's the two most important thing, Colin.
So let's talk about that a little bit, and I'll toss this one to Lucretia. When you talk about what a qualified informal resolution facilitator, mediator, whatever you want to call it, looks like, what does that person look like to you?
To me, I believe it's someone who's well-trained in mediation or conflict resolution or whatever that process is. I believe it is someone who is transparent with the parties, understanding, what they're looking for, and just really, really being trained in the process. I am not a trained mediator, so I don't want to touch an informal resolution process because I don't know the ins and outs. So that's why I'm saying if you have someone in your university who is trained as a mediator, utilize that individual or go to an outside third party. That's what I did at Wichita State because I had never, we don't have those individuals that can do the mediation. And so what I wanted was someone who was trained, who knew how to do it, who could offer the support that I may need and get that done, and then work with both parties. So I'm the proponent of a third party. If you can afford that, utilize that process and then make sure that those individuals are trained. I felt comfortable in doing that. But again, I can investigate and I can do all the other things, but the mediation piece was not my wheelhouse in that particular case. And that's why I utilized that. But you have to have trained mediators and be transparent and have the individuals, your mediator be transparent with both parties and your Title IX office, and making sure that, again, as Cara has said, and I'm going to quit talking here, is that your university, feels comfortable in your office, and they know that your office is, there's no conflict of interest, and that they feel comfortable in coming to your office. So that would be my takeaway and my question to you, Colin, long story short, making sure that those folks are trained.
Makes sense. One curiosity I have, and I know we're really bumping up the time here, so I want to make sure we get a couple of things, and then I'll just have one comment on all the questions and how we're going to handle those going forward to make sure everybody gets the answers that they're looking for. But I'm curious, coming off the pandemic, and now we've moved into a world where, even in B2B and B2C mediations, everything is moved online. What do you guys think the place of a technology platform is in this? And I say this of particular interest because I'm an older guy. I'm not old, but I'm 45. So I didn't grow up with cell phones and things like that. But I've always had a particular interest in these younger generations, the fact that they live on their phone and that's where they're most comfortable. And obviously the pandemic has forced us into a world where we're doing these things online. But do you think that's a beneficial thing? Do you think that's a positive thing for these proceedings, in particular, not getting people in the same room where they may have that friction? And I'll toss this to anybody who wants to answer it, any of the three of you.
Okay, so you know me, I do think that it is beneficial, the technology piece of it, because you're right. It minimizes that impact of having those people in that room. So it's beneficial to me. And that's why we utilize kind of an electronic process so that the individuals can do the mediation without actually being in the same room, having, or going, hey, what did you think? Kind of the back and forth. I think Jackie had mentioned earlier about the phone call here and the phone call there. So I do think that this is a much better medium than the electronic, doing it electronically. That's just my take on it.
Jackie, curious to get your take on it. I know we talked right before this all started about how you're able to do things all across the country now because of technology, but how do you think technology plays in this particular realm?
Oh yeah, I mean, I think it's great. We had a question in the Q&A about, when I mentioned earlier doing it in person, gets people more, puts more pressure on people. And someone asked, is that true even if you're doing it through Zoom or a technology? And I said, yes, there is obviously some additional pressure if you're all in person waiting to drive home. But I have the biggest benefit, I think, for my clients across the country of the pandemic is that now if they want me for something, they don't have to bring me there. So that's true for all of the informal resolution facilitators that you might be able to work with that can do it through an electronic platform.
Sure. And Cara, I'll toss it to you for the last word on tech and how it's involved in this process.
I think this is a good question. I think we've all evolved, me especially, because and I'll touch a little bit on like what Lucretia said and what Jackie said in my own experience. About 2 years before the pandemic hit, I moved from, so I work at Marquette, but I moved from Milwaukee to Des Moines, Iowa. And I continued in my role as Deputy Title IX Coordinator as on a remote basis. And I was very nervous about it because my main role is investigations. But I found through interviewing the students, the feedback from interviewing online, the feedback was tremendous. And maybe it's a generational thing. And they said, Cara, I could never have been as forthcoming with you had I been face to face. There was a security with a screen, because that's something that they've always known. And so when you transfer that into the informal resolution space, I think you're going to get that same feedback. Plus, it allows you to jump back and forth from the parties way quicker than walking down a hall into another room, getting distracted from other breaks. And so that technology platform, while it's great, also it's really creative because you have breakout rooms and there's chats. And so I think that I think the virtual world is here to stay. And I think we've got to utilize it. Plus, as you said, finding informal resolution facilitators isn't easy. And so to the extent you could even partner with other schools that say, hey, I'll serve as an informal resolution facilitator for you, if you in turn serve as an informal resolution facilitator for my institution, and we do an exchange of services that way, you can be anywhere in the country.
Well, this was fantastic. We are just a little over an hour, but I think with the starting time, we hit it probably at 60 minutes exactly. First thing I want to do is just thank Cara, Lucretia, and Jackie for being on this. This is hugely appreciated, incredibly informative. For everybody listening, we will do a follow-up email. We will make sure that we print all of the questions that have been asked and see if we can figure out a really good way to get you answers to those, so we're not just leaving those out there hanging. We will also, I will facilitate it through New Era to make sure that everybody gets connected in the best way possible. We will also be sending out a recording of this. So if you want to share it with anybody, please feel free to go ahead and do that. Or if there's information that you missed and you just want to watch it again, hopefully that is helpful for everybody. So one last time, just a thank you to everybody. Really, really appreciate it. And hopefully this was good for everybody. We're also going to try and do some networking events in the future. So we'll keep you up to date on all that good stuff. Thank you.
Thank you.